Live on Facebook, Abby. We'll be doing live on Facebook.
Oops. So I hope those online can see now. Okay, so I've been invited to talk about adjudicating rape cases, proof, trial, and punishment. Well, I think proof and trial would be more or less the same thing, and I'll try not to take too much time. So, what exactly is rape? Because it has become a very topical thing. And I'm going to be looking at rape from some definitions in our criminal state. I'm also going to talk about the Violence Against Persons Prohibition Act, but majorly I'll be looking at section 260, 261, 262, and section 137 in Lagos State. So what exactly is rape? I think, to put it very sharply and shortly, it's unlawful sexual intercourse. And it's unlawful because it's not with consent. In a very simple way, if you want to talk to a layman, because I think we need to do a lot of advocacy about rape. And we need to just break it down in terms, short terms that people can understand. So it's unlawful sexual intercourse. And let's look at what the criminal law says about that. Any man who has unlawful sexual intercourse with a woman or girl without her consent is guilty of the offense of rape and liable to imprisonment for life. Generally, the sexual intercourse unlawful is that they consent, and that's just the bottom. Threat or intimidation of any kind, fear of harm, or false or fraudulent representation as to the nature of the act. And subsection 4, sexual intercourse is complete on the slightest penetration of the vagina. So from this definition, the ingredients of rape are: one, that the accused has had sexual intercourse, and we don't talk about victim anymore. We call the person that has survived the crime a survivor. So I've used the word survivor throughout. And B, the act of sexual intercourse was done without her consent, or that the consent was obtained by fraud, false threat, intimidation, deceit, or impersonation. C, that the survivor is not the wife of the deceased. And D, that the accused had the mens rea, that is, the intention to have sexual intercourse with the survivor without her consent, or that the defendant acted recklessly, not caring whether she consented or not. So I'll go to section 261, which is sexual assault. Any person who penetrates sexually the anus, vagina, mouth, or any other opening in the body of another person with a part of his body or anything else without the consent of the person is guilty of a felony and liable to imprisonment for life. So arising from this provision, the salient elements that must be proved before the defendant can be convicted of sexual assault by penetration are whether there was penetration through the victim's anus or the survivor's anus, vagina, mouth, or any other opening in the body of the survivor. Whether the penetration was sexual. 3, whether the penetration was done by the defendant with a part of his body or anything else. And 4, whether the penetration was without the consent of the survivor. I'll go to section 262. Any person who attempts to commit the offense of rape or sexual assault by penetration is guilty of a felony and is liable to imprisonment for 14 years. And that just means any attempt to perform any of the other acts we've talked about is an offense in itself. Section 37. Any person who has unlawful sexual intercourse with a child is guilty of a felony and is liable to imprisonment for life. When we draft our laws, I think certain things should be taken into consideration. When you say any person who has unlawful sexual intercourse with a child, it gives the impression that it is possible to have lawful sexual intercourse with a child, I guess because of the issue of the age of marriage. But really, it should be any person who has sexual intercourse with a child is guilty of a felony. I do not see how sexual intercourse with a child can be lawful. Now, the elements, and that's defilement, the elements of defilement to be proved by the prosecution are that one, the survivor is a child. And who is the child? Section 418 of the Criminal Law of Lagos State. A child has the meaning assigned to it under the Child's Right Law of Lagos State. By virtue of that law, Section 261, a child is a person under the age of 18 years. And the second ingredient is that the defendant has penetrated the victim. And you can see here. Now, those are the enactments we're looking at. So I go now to the case law. In our case law, based on the provision of the Criminal Code, rape was defined in POSU and states, and the citation is there. Now, Mr. Adikeye of the Supreme Court had this to say, that rape in legal parlance means unlawful carnal knowledge of a woman or girl without her consent, or with her consent if the consent is obtained by force or by means of threat or intimidation of any kind of, or by fear of harm, or by means of false and fraudulent representation as to the nature of the act, or in the case of a married woman, by personating her husband. Then I'll go to the Violence Against Persons Prohibition Act 215. This act has done a lot concerning rape. I'll talk about the definition and then go on to what more can be done, with the act. Now, when a person, that's section 1, intentionally penetrates the vagina, anus, or mouth of another person with any part of his or her body or consent, or where such consent is obtained by force or means of threat or intimidation of any kind, or by fear of harm, or by means of false and fraudulent representation as to the nature of the act, or the use of any substance or additive capable of taking away the will of such person, or in the case of a married person, by impersonating his or her spouse. This is a very wide, far-reaching definition because it recognizes the issue of substance used to take away consent. It also, by this definition, both males and females can be raped, and rape can be by, the anus or the mouth. So it's a very far-reaching provision. It's also very interesting that the Act appears to recognize marital rape because it just says any person, Now, it is also provided that an attempt to commit an offense is an offense in itself, just like, in the Criminal Law of Lagos State. Now, one thing that is also new is that the Act makes provision for compensation to victims as well as protection of their rights. Now, unfortunately, the Act only applies in the Federal Capital Territory and is not binding law in the state by that state. So only the High Court of the Federal Capital Territory has jurisdiction to hear and grant any application brought under the Act. So that's one downside of the Act. Now, I've, gone through the definitions, for, and that's the technical, part of it. That's just definition. Now, going on to, should I say prosecution now and trial? I'll just take, what are key elements. Now, the first ingredient of the offense of rape is sexual intercourse, and it can only be successfully established if there is proof of penetration. What is penetration? The ninth edition as entry of the part of the body, a foreign object into the vagina or other part of the body, vagina or other bodily orifice. And again, is not the definitions that we have. Now, under case law, the same case of POSU and state, and this was Justice Fabi of the Supreme Court here, who says it has been held important ingredient of the offense of rape is penetration. However, penetration with or without emission is sufficient, even where the hymen was not ruptured. The slightest penetration will be sufficient to constitute the act of sexual intercourse. And sexual intercourse is complete upon proof of penetration of the penis into the vagina. We've seen that we can depart a bit from this to see that it's not only a case of, the penis now, it's any object actually used. Defilement, we usually talk about men using, their fingers. And if we go by that wide definition in VAPP, of course, it would also mean, whatever can be inserted into any part of the body, the mouth or the anus and all that. Now, we've on the issue of penetration, and one of them is that there need not be complete penetration of the labia majora or vulva, and an attempt at now that's about penetration. I want to talk about the issue of how do you prove penetration. We're talking about what is the evidence, and it's been held that there must be corroborative evidence other than the say-so, other than the ipsy dixie of the survival. There must be some other evidence that shows actually penetration. Usually, because and that's one of the big issues, which I'm sure that other speakers will talk about, particularly Mrs. Vival. The issue of how immediate the medical evidence can be obtained, how immediately after the rape, because in one of the cases that my sister judge had determined, this was an unfortunate case. The principal of the school had been having sexual intercourse with kids while at school, 14 or 16, and one of them got pregnant at 18. And even the parents aborted the pregnancy. So how much proof, are we going to have? Long period of time and all that, but in that case, there was still his content was good enough because he had to make the case that he had a relationship with both of them. But that evidence of penetration by medical records is something that we really don't have a lot of times because people don't report the case actually done. And even then, what the law says is that there must be corroboration of the evidence of the victim or survivor, as the case may be in a rape case. Even though, it's not required by law, but from our practice, we say there must be some corroboration. And I think that is all well and good because, unfortunately, people have jumped on the bandwagon of rape, and we have a lot of false accusations now. It's just very unfortunate. Now, the court can also make, inference from surrounding circumstances. And that was decided in the case of Onyiwa and State. But the nature of the corroboration must depend on the peculiar facts of each. Evidence of rape is denied. The evidence of corroboration that the court must look for is, for instance, the medical evidence, like I mentioned before. That is very, very important where there's a denial. Like I was saying, in the case before Justice Sholeba, I've forgotten the name of the parties now, the man actually admitted the rape, although he didn't call it rape. He said, he had a relationship with this two children, and that the one that got pregnant for him, he was ready to marry her, but her parents had pregnancy. I mean, there was clear admission there. But here, when there's denial, the private part or other parts of the survival, which may have occasioned the struggle. They've also talked about or And of course, it doesn't have to be direct evidence because rape is not committed in the open, as was decided in the case of Mohammed in Kano State. So, difficulty we have in proving penetration, because the most valuable evidence that we can have on penetration is
Come and get it. Yes, inside the I'm teaching the Baba
application. I am clear. Has there been any chat?
Number one,
Can I have an
right there.
Can I have an invitation?
Right, you underline the answer. Do number 1 to 5 right now.
Can you hear me? Hello, Mr. Akilade.
We can hear you, my lord. We just tried to
okay, yes.
somebody who came in without muting their mics.
Yes, I was trying to chat anyway, so if you hear me, I just want to be sure so that I don't just go on and then I'm not, being heard. So yes, that first ingredient of penetration, is a major thing, and that's the problem of medical evidence, because that's the best way to prove penetration if there is no admission. And on to the next serious issue that arises, in these cases, and that's the issue of consent. And consent is the lack of consent is what actually makes sexual intercourse unlawful. It is unlawful only, and it is interesting that in subsection 3 of section 260 of the Criminal Law of Lagos State, the law says expressly that consensual sexual intercourse between unmarried persons is not a crime. So what really creates the offense of rape is the lack of consent. So the next ingredient that must be proved is the absence of consent. Now, there's instances in which the law automatically says that there is no consent. The law presumes it, and it's very difficult to report. You also need medical evidence to report it, and that is where it is a child. Once someone is less than 18 years, you cannot say that the person consented, no matter, even if they wrote, if you put it in writing in blood, I hereby consent to this rape, and the person is less than 18, sorry, the law says that person is incapable of giving consent. So now, section 27(2)(a) of the Child's Rights Law provides that where a person is charged with an offense under this section, it is immaterial that sexual intercourse was with the consent of the child. A child is not capable of giving consent. I remember some people came to me about a matter. I wasn't fortunately in the criminal division then, I was in the commercial division, and these people said, they wanted my intervention and what, and a pastor was involved and all that, and I was, willing to listen. And so man who is very well educated, he's an architect, so I'm surprised, and he's said to me that, we've had a problem with our pastor, and I think maybe he's been having an affair with this girl, and all that, and anyway, there's now a police matter. And I said, what is it exactly? And then he said, he had been sleeping with his house help, who was 16. I jumped up from my seat, I screamed, and he was so afraid. And I said, forget about it, it is rape. And he couldn't believe how I reacted. And I said, how dare you come and talk to me? I can't even believe that you do not know that sexual intercourse with a girl who is 16 is rape. It doesn't matter. How can you say a 16-year-old is having an affair? It is impossible, And it is an offense that is strict liability. You can't even say that you did not know that the person was 16. Sorry, too bad. Even if she looks like a 25-year-old, once there's proof that this person is under 18, then there cannot be consent. So we look at section 31, it's still the same thing. It's an offense to have sex with a child. Therefore, sexual intercourse with a child under the criminal law of Lagos State is a felony, and the person found guilty of same is liable to be punished with life imprisonment. So, like we said, consent is immaterial. Now, another situation in which the law presumes, presumes that consent can't be granted, is where the ability to consent has been taken away. You take away somebody's ability to consent and then say the person has consented, and that is captured very well in the VAPP, because that says if you give somebody substance that alters their will and makes them incapable of actually consenting, then you cannot claim that they consented. So a person of diminished capacity, either by reason, and also, of course, you have some people that are either maybe, for want of a better word, imbeciles, or they are challenged, or they are, what's the word again, disabled or something, and unable to actually have full mental capacity. And then you take advantage of the person and claim that that person has given consent. The law says if a person has diminished capacity, either by reason of mental incapacity or some altered mind, that person is unable to give consent. So in those cases, you cannot even prove, and it cannot be a defense that the person consents. So that's the issue of consent. Now, sorry, that's. Sorry about that. Now, and I think those are the two, major facts that must be proved in rape. Those are the two. I mean, once you can prove that there's penetration and you can prove that that penetration was without consent, then rape is made. But how do we actually tie it up? And that's why I have picture here, because we find out a lot of times, yes, you prove the penetration with medical records, and you also prove that this person claims that somebody slept with me and I didn't give my consent. But we've had instances where you do not actually even tie the defendant or accused person to the rape, and because Justice Sholebo gave me quite a number of cases. In one case, it was very unfortunate that that person escaped, that's my view, judgment, because the survivor of this rape crime was a 70-year-old woman. But she could not, there was no way, of course, in Nigeria we have this problem, and I've talked about it in some interviews, of forensic evidence. So there was no evidence to link the defendant to that rape. There was, of course, no DNA, no semen on clothes and things like that. So it was impossible to actually prove that. In fact, if somebody slept with you, it was this man that did so. So in practice, we find that the prosecution sometimes falls short of tying the defendant to the crime. Of course, it's difficult. Usually, like we said in the case of Mohammed and State, that, and Kano State, that rape is not done in the open. You don't invite people to come and watch you while you're raping somebody else, except maybe some cult things in universities and things like that. But sometimes people are fortunate you can actually have an eyewitness account. Sometimes, of course, it's a confessional statement or circumstantial evidence. But the prosecution must not forget to tie the defendant to the offense of rape. It's something that practically we find wrong at times. So, talking about witnesses, Justice Bible said in Loki and states that sex is usually not performed in the presence of a third party. In most cases, it's a hidden act performed behind closed doors, away from prying eyes. It is rare to get a witness to give evidence on oath that he saw the appellant have sex with the victim. So, of course, we have no choice in such cases but to, look into circumstantial evidence which must be positive, compelling, and direct. And there was one of the cases that I had also got from Justice Sholebo, in which this young lady, she was married, and the defendant was supposed to be her husband's friend, and she had some like a bar or something, and this man came in ostensibly to buy drinks and looked around and there was nobody, and did the rape. And in that case, the defendant's defense, part of the defense was that the survivor had claimed that her clothes were torn and that the prosecution did not bring the torn dress. And what really is the relevance of that? There was other evidence around the fact that he admitted that he went there on that day. There was nobody there. Or he said, he only went to drink. He didn't, and all that, and some silly questions. But the circumstantial evidence was compelling enough in that case to tie the defendant to the case. So that's one of the issues of proof that I thought it's important to raise. Another issue that arises in proof of rape is a lot of times, because of the stigma in our society, and sometimes because of the length of time, because like I said, sometimes it takes a long time before the case finally comes to court. You find places where the victim or the survivor of the crime is not available for some reason. Perhaps because of the stigma, they don't want to come to court, or perhaps they've even, because of what happened, had to relocate. Stigma also, again, shame, and the person has relocated, or some other reason, the survivor is not in court. And the defense always, jumps on that and says, well, how can you be proving this case? And usually, when you want to prove a crime, yes, usually you expect the survivor. But in the instances of rape, I believe that you can go ahead and prove and succeed. And it has happened before, and it happened in a number of cases that I've seen that, despite the absence of the survivor, who would have been a key witness, can that person please mute themselves, please? Thank you. Now, so the person, someone's got children in the background, so I just ask if you can mute that. Your Mama. That Mrs. Adeniran, if it's you, please can you mute? Mute. Okay, so is it possible to prove when the victim or the survivor does not attend court to testify? I believe so. You can do it. If you have other compelling evidence as well of that survival, I see no reason why, the charge should not stick. And of course, relapse can be placed on Section 46 of the Evidence Act. So I think that and proof. I'm sure we'll have time to ask questions later. So I just sort of did like talk general. Then, of course, we're talking about punishment. We found that it's life imprisonment. And the issue is that's the maximum sentence. Yes, in a lot of instances, you find that there might be some circumstances that would warrant not giving that maximum sentence. But I believe strongly that in cases of defilement, and that's the sexual intercourse with the child, the maximum sentence should be given all the time. Maybe in some other instances where both people are adults and something happened, yes, you can give 14 years, 15 years. That's my own view. And so, but it's important that if one is given a term of years, a sentence of a term of years, it should run from the date of pronouncement. Because, we had this situation where sometimes you'd commute the sentence to when the person was first arrested or taken into custody, which is wrong. It's not legal. What the law says is that you can take into consideration the fact that this person has been in incarceration a number of years in the sentence that you give. Not that the sentence should run from the date the person went into custody. And although it is not provided by law, but what I found Ekiti State, and I'm very, very happy that we have that proactive. I really didn't look at the provisions of Ekiti State, but I know from the news and social media that Ekiti State actually has a register of sexual offenders, and they make it public. I think that of stigma, there's also protection. If there's a sexual offenders register and you have a school you want to employ, you're able to do a search and find out whether this person is worth putting with children, because we've had a lot of instances where we have children being abused by teachers and other persons in authority. And that will finally take to, there's a bill, that's not, anyway, I'll go back to that bill. The bill that is being, maybe we'll just take that under discussions. The sexual influence, I think it's called, I'll look at it again, but the bill that is being proposed now to deal with the issue of teachers or professors or tertiary institution where the lecturers use their authority to hold the students to ransom and then have intercourse with them and claim that they're having a relationship. It's been made a strictly offense. I write up about it. I'll look at that when I'm done with all this and maybe in the course of questions. Now, of course, we've talked a lot about rape and how terrible it is and how depraved it is. Unfortunately, we have people who actually falsely accuse, and it's painful because it just does not allow the good that needs to be done. So we've had instances. What are the defenses that if someone actually is wrongfully, that can prove that someone is wrongfully accused of rape? And I've talked about impotence. It might be unlikely or people may not want that defense, but if actually someone is impotent and then is accused of rape, it can have stigma of being a rapist or the truth of the fact that he's impotent. And, of course, there's defense of alibi, which has also worked. If the person would not have been there, then now proof of consent. Like I said, for the statutory cases, you cannot prove consent. There's no defense. You cannot say consent is the defense. But sometimes when there are two adults in a relationship, like subsection 3 of section 260 of the criminal law makes out, if there's consent, then it's not a crime. So if someone can prove that, yes, there was consent. Then, of course, we talk about inconsistency and contradictions in evidence. You can prove that too and say that a case of rape has not been made out. There's also the issue of inadequacy of forensic evidence or medical reports. If there's something wrong with the medical report, or you can prove that the medical report does not relate to the victim, for instance, something is wrong with the medical report, or it's inadmissible and all that, Because in the case I was talking about the 70-year-old woman, the medical evidence was not admissible for some reason. I think the wrong person brought it to court and all that. So, yes, you can have a good defense with that. Of course, insanity can also be a defense. So, I looked at defenses without going deeply into them. And those are my few thoughts and words on how, the offense of rape can be successfully prosecuted. So, if there are any questions, I can take questions while I quickly look for my write-up on the bill that I was talking about. Thank you very much.
Thank you very much. Thank you very much, my lord.
While my lord was speaking, we had the chairman of the Nigerian Bar Association Ikorodu branch walking we'll give him a few minutes, maybe later in the session, to say a word. The vice chairperson of the Nigerian Bar Association Ikorodu branch also is in the room. She's the major host for today's program. And as my Lord was speaking, Honorable Justice Cholebo came into the room. So I've asked my Lord to follow up on what Honorable Justice Williams had said and perhaps give us some insight as to what lawyers should or should not do in actual cases of rape. My Lord, Honorable Justice Cholebo, are you there? Can you unmute your mic and maybe put on your video if it's possible? But my Lord, okay, thank you, my Lord.
Good morning, everybody. Good morning.
Good morning.
Morning, everybody.
Good morning, my Lord.
I'm glad to be part of the discussion. May I seize the opportunity to commend my Lord Justice Williams. She was my lecturer at the law school, so I'm not disappointed at the grade of lecture. Thank you, my Lord. Is there anything much to add to what she had said? I think she has highlighted part of the problems in court. Few occasions rather, I find it difficult to ground conviction because of some of the things she had highlighted, particularly the case of linking the defense with the commission of the crime. I think that's an area where we have to look at. I know most of those I'm speaking to are actually defense counsel, but for prosecuting counsel, I think it's germane that the prosecutor is able to link the defendant to the commission or the perpetration of the crime. Otherwise, we would continue to lose good cases. I think for defense counsel, I think we should adopt good practices internationally where your client is actually guilty. There's no need wasting the time of court. I think it's better to just come, allow the defendant to plead to the crime, and of course, do a plea bargain and ask for lesser sentence. It saves the time of court, it saves the stress anybody will go through. Even the trauma, either the defendant, both the defendant and the victim would also go through, because even the defendant, you can imagine coming to court for 1 year, your case is not determined, they go through a lot of trauma. And most times they're not able to even perfect their bail. That's also a problem. So I think defense counsel should also consider that this takes a while to determine. So do a bit of plea bargain so that your client can get lesser sentence. I think basically it's in order to give others room to speak. In addition to what my Lord Justice Williams had said, I just added that at least for the prosecutor and defense counsel. I thank you all for listening, and Mr. Akinlade, I'm grateful for giving me the opportunity to speak. Thank you.
You're welcome, my Lord. Honorable Justice. What's there, and we as lawyers will try to ensure that we give the best advice to our clients, and that's why we are having this session. I also noticed that Mrs. Bosede Ayodele, former DPP, is also here. So perhaps from the perspective of the prosecution, she may want to say a few words. Mrs. Ayodele, please, you can unmute your mic.
Good morning, everybody. Particularly my brother, Mr. Akinlade. I want to thank you for what you are doing, and that in the fullness of time, the Lord will reward you. I also want to appreciate my sister, Honorable Justice Williams and Justice Cholebo. thank you for the presentation. It's been very wonderful. I just want to comment the fact that these days people are now beginning to come out to speak out about this thing that has taken over our land. It's not that it has never happened. Now is that people are becoming more aware. People are getting bolder to speak out. I recall that in my days when I was DPP, we never really had a case of rape to decide on. The people were not forthcoming and they were not coming. But gladly today, people are coming, and it's already a pandemic in our nation. And I think it should be fought thoroughly. I thank the two presenters of these papers taking us through how to do the prosecution, and particularly the prosecution, like it has been highlighted, it's very hard to prove. But with all these things that we've been taught and told, and then the new things that are coming on board, the DNA that Lagos State has put in place will also help in this area. And a lot of NGO that seem to be interested in fighting this malaise, I think that it will go a long way to ensure that the perpetrators of these nasty things are brought to book. But I want to also emphasize that we must be very careful, because I recall a matter that I got to know, a case of a tenant who was living with a landlady, and the landlady wanted to reject the boy, but for no reason, and the boy was not ready to leave the property. The landlady had to go and report at the police station that this guy raped her daughter. So such a difficult thing to get to the boy out, because at the end of the day, the little girl now said that the guy did not rape her, and that it was her grandmother that said that she should say that so that the boy can be taken out of the house. So in terms of prosecution, conviction, all these things must come to bear, especially more so that the punishment is a very heavy one. So it would be nice for the prosecution, the defense, and even the judges to be very careful in getting people sentenced for this particular offense. And it's so heartbreaking that the thing has become so I don't know what to say. Sometimes I begin to wonder why a 3-month-old baby will be raped. It's so sad and all of that. And I think something drastic should be done about it. And that is a good thing that Mr. Akinlade has brought this kind of training, I would say, to take people, counsel, and even parents and all of that have joined in this program to know how to go about it, to be able to report in good time, to be able to seek medical attention for the victim and all of that. I myself have gained a lot. Although I'm retired, but I still do a bit of practice, and I think I'm better for it with the little training that I've got this morning. So I want to appreciate the judges, the presenter judges that have done a wonderful job taking us through the ingredients of the offense and how to go about, so that at least we'll be able to get conviction for the offenders. I'm glad to be here, and I appreciate all. Thank you. I wish everybody well. Thank you.
Thank you very much, Ms. Ayodele. Please, if you have any questions, you can actually type it out. We want to run through this quickly. My Lord, Justice Williams, perhaps maybe we can take some of the other speakers and then do, if my Lord is not in a hurry to leave. My Lord, Justice Williams, would you like to wait and take everything, or you would like to take the questions? Please, your mic is still unmuted, and I would appreciate if others mute their mics, please. Techno C9,
yes, you are saying.
Mute your mic.
Yes, you are saying, would I like to what?
My Lord, we wanted to know if my Lord would take questions now or wait for a while and let the other speakers speak.
I would like to take questions now, but I just wanted to quickly I said that I was looking for the write-up I saw on the proposed bill, and then I also want to. I was, in conversation with Justice Sholebo, and she's saying that the issue of the registrar, the register of sexual offenders, that while there's a law in Ekiti, based on policy in Lagos, we really have that register, but it's just policy, and that there are moves to actually make it a law. But for now, it's not a mandatory, it's not a law that, you should have a register of sexual offenders. But like I said, I think that's a very key thing. Now, I was talking about the proposed the sexual harassment amendment bill, I think it's going to be, and it's talking about sexual intercourse by lecturers in higher institutions, And the intention is to have a 14-year jail term, for any lecturer that has intercourse with the students, and I think I think it's a strict liability offense because you are just not allowed to have intercourse with any student except the student is your spouse. That's just what I wanted to, add. I had mentioned it before, but it's a bill that I think it's past the first reading. I think that's, so that's what I wanted to add. But if there are any questions, yes, I think we can take questions quickly so that I don't come back after people have spoken. I still will wait because I want to be part of the discussion, but it's better to take the questions now so that I'll be totally, done.
Thank you for that wonderful presentation. Now, I would like to ask, you mentioned during your presentation that there are circumstances that makes it impossible to give consent. I would like to ask, from a judge's point of view, how can you prove that it was not a sexual intercourse wasn't consensual if everybody perhaps recognizes the environment and feels that whether I struggle or not, I will be overpowered. So let me just give in and get out of the circumstance. Because although I don't want the sexual intercourse at that point, but there's nothing I can do. And medical examination, usually when you have bruise on but all these things actually goes to corroborate the evidence of rape. But in the circumstance where I don't struggle or I give up on struggle, how confident will it be for the victim to prove?
I can take. I'd like to take all the questions. So if there are any more questions, then I'll just give the answers.
Is anyone online, please, you can unmute your mic and ask your questions.
Okay, hello, good morning. My name is Adefoke Ayoponle. I just want the Honorable Justice Williams to maybe throw more light on this. If it is possible for us to begin to use the rape kits. I think the rape kits, like I know, is more like a kit or an instrument that is used to preserve any rape that has occurred, no matter the number of years, so that evidence will still be intact. So I just want her view on the issue of rape kits, if it's possible or doable for us in this country. Thank you.
Any more questions? We'll take maybe 2 more questions and then we'll allow my Lord to respond. If you have any questions, please unmute your mic. I think my Lord can go ahead and answer the questions.
Good morning. Good morning. Good morning.
Good morning.
Hello.
Good
Okay, I have a
morning.
question. Okay. What is the likely evidence in a circumstances where the victim is dead? What will be the criminology or the effects when you have a dead victim?
Criminology of what?
Of if the victim is dead and there's no evidence to prove that the person is actually raped or not, what will be the evidence in criminal effects when you have a dead victim?
Yes. Okay. Is there any other question, or I can answer now?
Good morning. I have a question.
Yes.
Can I go on?
Yes, please.
Good morning. I have a question. Can I go on?
Please go on.
Yeah. My name is Oluwasewaka. I have issues. I wouldn't know what is the earliest possible time, or the latest. Let me put it like that. The latest time that a rape victim could come out to say she's being raped. I find it difficult when I see female ladies coming out to say I was raped some 5 years ago, I was raped some 10 years ago, and they just make up issues on that, and the whole society begins to, look at the accused. Even we as lawyers, we know it may be very, 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 very hard, if not impossible, to secure. And what are the possible consequences where
My Lord, I think because he's driving, he probably entered the dead end. We have one other questions from the
as a
floor.
blackmail?
Good morning, my Lord. My name is Shagun Shugun. My question is centered on sex between minors. I just want to know the position of the law where we have minors that are involved in this kind of sexual situations. For instance, there was a case handled a year where a minor accused another minor that he raped her. So I want to know the position of the law. For instance, as a defense lawyer, what I can do if I believe my client is innocent of the accusation, what I can do, or what the position of the law is generally on sex between minors.
So I don't know if I can go. I think I'll start from the question on a dead victim. And I'll say that if you have a dead victim, do you mean a victim that died as a result of the rape? Because if a victim died as a result of the rape,
Of rape, yeah.
what the prosecution would
Mm-hmm.
be proving the murder than the rape. But, like we said, it's always the issue of medical evidence. If it can be shown by because medical examination usually shows the cause of death anyway. So medical examination would show that died as a result of the rape. And please do not forget that you said that even when the survivor is not in court, you can see the evidence and not rape. I don't think that if that happens, prosecution will spend their time proving rape as the cause of the child murder or manslaughter. I think that is what will happen in such a case. The prosecution will be looking on the crime of manslaughter and prove that manslaughter came about as a result of the rape. That's the question, my answer to that. Then there's a question about rape kits. I think we all know that problem of funds, financing. Mrs. Adeniran, you're going to have to go either mute yourself or stay away from it. Yes, so talking about the rape kit, we always have, a state of utopia where we think we can. But I believe that we can work with what we have. Lagos State, like Mrs. Adele was saying, has done this forensic lab, DNA. We can start. But if the government can provide rape kits for the police, I mean, of course, it is only going to help to make things better. And dovetails into what question asked. Because if you have the rape kit that is able to preserve evidence for a number of years, then that evidence will be there and it will be good. So it's a good thing. I hope we'll get to a place where we can have them. Now, so to go on to Mr. Aka's question, it is unfortunate that this societal ill actually has backing. And there are rape apologists. A lot of men are rape apologists, even women are enforcers. Now, every crime, there's no statute of limitation for any crime, and you know that. So to say that somebody comes after 5 years, why should rape suddenly have a limitation? Why? No offense. The statute of limitation does not work with offenses. No offense is, so you can't come and say, I have no doubt that there are false accusations. But if somebody is able to prove that they were raped 20 years ago, it is still a rape. And in that case of the twins that I was talking about, this child had been raped. The parents had performed abortion, but the rape was still proved because the man admitted. So it's possible to prove rape no matter what time of years. But of course, like I said, and Mrs. Adele was saying, we talked about it, there are accusations. There are a lot of false accusations. I mean, she talked about the case of a tenant. I also know about a case about some young boy that we had picked up from these drug places, and he had been sheltered, and he also was put in a place. And somebody saw their grandchild having a close relationship with the guy. They hadn't even, they hadn't gotten to the point where they are going out, but the girl just liked the boy. And the grandmother felt, what? This boy that used to be a drug addict, I can't have that. And then accused the boy of rape. So yes, there are false accusations, but like every other crime, there are false accusations. So it is the prosecution and the defense that have to do their job properly. So the fact that there are false accusations cannot blind us to the fact that rape could have happened. And there are people that consistently rape their wives. The case I talked about, that somebody said to me that a pastor was having an affair with a 16-year-old child, that is a very painful case for me, because this girl, the pastor started raping her when she was 13. She never saw her period. When she was like 15 and her period was supposed to start, she got pregnant. He did 3 abortions for this girl. All this was discovered when she was 16. And the wife was trying to say that, yes, this girl was having an affair with my husband. What are you talking about? So do we say because he has been raping her for 4 years, why didn't she come out? Why was she quiet? And do you know that in that instance, the only reason why it came out was because this man confessed to a friend that, I have this affection for this girl and I don't even know what I'm going to do. Maybe I should send her away after committing abortions for a 15-year-old. So let's just not make any bones about it. There are many reasons why women keep quiet. And one of it is stigma and the failure to understand what women go through. So we can't talk about years here. The issue is, and you find people who admit anyway. So I think that no matter the number of years, there's no statute of limitation. If it is a false accusation, if the defense counsel does his job well, he will be able to prove it. And the whole point is, it has to be proved beyond reasonable doubt anyway. So I'll go on to the first question about where somebody just gave in. How can we prove whether there was consent or no real consent? Like we said, circumstantial evidence is one. Now, if don't forget that the law already makes provision that if the consent is by threat, and all. So in a case where it's your word against mine, that's what is going to happen. Because the girl says, oh, this and this happened, and I just gave in, because that comes under rape. Because the law says if the consent is given by threat or deceit or whatever, it's not real consent. So how are you going to prove it? You tell your story and whatever evidence, and then there's cross-examination. So it's just proof beyond reasonable doubt, like in any place. But it doesn't mean that where somebody just gave in because of the circumstances, then it is not rape. It is rape, but it's always the question of proof. And how that can be proved is the way the person tells their story. We have this big issue about the Banj and this girl, on social media and all that. And if it ever goes to court, it's going to depend on how the defendant is cross-examined. And so that is the job of the prosecution and whatever circumstantial evidence there is. So it's just a question. There's no special way that I can deal with that except to say that in the course of getting evidence from the defendant, cross-examining him, talking about the circumstances, every other thing that took place, and how she would say that her consent was actually taken away because of the threats that she had, that she perceived. But with a lot of what were, the advocacy about rape now, I think women are learning to protect themselves more. Even men are learning to protect themselves, because women actually give their consent sometimes and then turn around and say that I didn't give it, maybe for reasons best known to me. Maybe I expected him to marry me and he didn't marry me, so I turn around and say I didn't give my consent. Then I was reading online and someone was saying, well, try to record if you want to protect yourself and all that. But it's a it's a risk for everyone involved. What other question? Yes, sex between minors. Well, as far as I know, if somebody able to actually rape.
Impact is the most balancing. It's volunteering.
Please, can you mute yourself?
Oh yeah, I put it off.
Miss Ogini, please, can you mute yourself? Thank you. I think that's a social welfare thing. There's no doubt that if there's proof, it's an offense that a child has committed, and under the Child's Act, it's something that it's a family law matter. But you are talking about where the minor is innocent. Like any other crime, a crime that is being treated, the defendant proves their innocence. So the fact that this person is a minor does not remove all the need for proof. It's just when the issue of punishment comes in that we think, okay, what's going to happen with the minor? But if you have a minor what is a minor? A 16-year-old who is able to have sexual intercourse, and that 16-year-old rapes a 13-year-old. The same system of proof. It's when it comes to how do we deal with the crime in sentencing and all that, that the fact that the person is a minor comes up. Because I don't know, about 10, 15 years ago, there were two cousins, and one was 9, and the other one was about 12. I don't know if anybody remembers. And this 12-year-old impregnated his cousin, and she was the youngest, was a 9-year-old. She carried the pregnancy to term and had the baby. But there's still the crime. So there's a possibility of a minor committing this crime. There's no doubt about it. It's possible. It's the issue of sentencing, what's going to happen when the crime of rape is proved. Because the law says that it is only an adult that can commit rape. So it's a crime like any other, even if it's a minor. It's only in terms of sentencing, and that I believe the issue of whether the person is a minor comes up. I don't know if Justice Sholibo has something to say about that, but I think that's my comment on all the questions I've had so far.
Thank you, my lord. I think Justice Sholibo would have something to say, and she's been on the chat box, but I will thank my lord Justice Sholibo to add to this question here. My lord Justice Sholibo, you can unmute your mic.
Thank you once again. Yes, I have listened to my Lord Justice Williams. I think that's the correct position. When it's a rape between two children, of course, it's at the stage of sentencing that we consider the age of the perpetrator, because the law says any person. Any person includes a baby. So that is, any person could commit the crime. But like my Lord said, it's at the stage of sentencing. And of course, the trial will be based on the procedure adopted in the family court, since the child will be tried under the family child's right law. So, and that will include the way the child will be sentenced. No doubt it is a crime that could be committed by anybody against any other person. With regards to the issue of rape kits, I have posted something and I'll just summarize that basically rape kits is not for the preservation of evidence. It is actually used by medical personnel, basically doctors in health centers. Lagos State distributes it with 57 health centers within the state and the teaching hospital, LASOs, and the general hospitals. And of course, the doctors are trained to handle it. At the last meeting I went for, it is now a part of the curriculum of training of new doctors and nurses employed in Lagos State on as to what to do. But that's it. That's what they use rape kits for. It is actually to ensure, to determine whether the perpetrator had infected the victim with any disease, HIV, or whatever. And I think once it is established, any of the diseases, they have a way of treating them that it will not go beyond, even if the perpetrator is HIV positive. The report we've always thought is that after 6 months, a further test will be done. And of course, most times the HIV is cleared. So the victim would not, or the survivor would not be HIV positive. And it's also to reduce mortality rates. You know, these are mostly children. We don't want them to die at the stage of giving birth. So once the parents don't have objection to pregnancy or something, I think a lot of times abortions are done, or where they want the child to commit to keep the pregnancy, the child will be taken care of by the state. That's the essence of all this medical kits. It is not for lawyers or police to handle. So, and of course, the victim must present within 72 hours, within 3 days. I think medically, there's still a way of determining some of these things, whether there was sperm, and of course, the freshness of the injury, bruises to the genitalia. So that's what rape kits is used for. And like I said, it's being handled throughout the health center, 57 health centers in Lagos State. In addition to the question on consent, yes, I have handled cases where the girl, of course, an adult at this stage will say, yes, it's my boyfriend, or the defender will come and say, she's my girlfriend, we were watching pornography. If your girlfriend comes and watch pornography with you, in my opinion, tactically, she's saying, I am available. But once you start touching a girl and she feels, oh, sorry, I don't want to go beyond us watching it, you know. But once you go beyond, I am sorry, don't go further, then that consent had been withdrawn, and anything thereafter amounts to lack of consent. That's the way it works. So it's not like she's my wife or she's my, of course, marital, there's no marital rape in Nigeria. I want to believe generally in Lagos, but generally in Nigeria. But of course, between girlfriends and boyfriends, you could consent as an adult, but once it's withdrawn, the man must take it and stop. Otherwise, it will amount to rape. Anything done contrarily thereafter. That's the addition I want to add. Thank you.
Please, sir, Mr. Bayo, please, I have a question for my Lord, please.
Meeting was going on.
Because
we have the chairperson of FIDA coming to the room, and we also have Mrs. Ogulami Fumilola. I believe it's the same name. She's the immediate past PS and Solicitor General of the Ministry of Justice in Oyo State, and I believe she was a former DPP as well. Before we come to Ms. Shola Shoyemi, I'd like to give the microphone to the chairman of the Nigerian Bar Association, Ikorodu.
Thank you, my Lord. Thank you, my Lord, for that insightful.
Please be seated, my brother. Please be seated.
My question.
Thank you.
And it was born out from the advocacy that the domestic violence of our branch carried out yesterday and the day before when we went to various communities. The recurring question from men are to the effect that there has been rampant cases of women sexually abusing men in the communities nowadays. And they ask us as lawyers that, is that rape? We are quick to tell them that by the statutory provision, that is not rape under our laws, but it can amount to an assault. I'm aware that this discussion this morning is about rape, but since we have the benefit of experts in the House, especially my Lord Honorable Justice A.O. Williams, I want your Lordship to advise if there are sexual abuses from women to men, under what law can we situate that kind of sexual abuse cases? Thank you, my Lord.
My Lord, go ahead and respond.
Yes. Okay. One of the things I had talked about was VAPP, that under the Violence Against Persons, Violence Against Persons, Violence Prohibition Act, the VAPP, that it's possible to actually rape a man. You know. But of course, that has not been adopted into law in ours. Well, we talked about sexual assault by penetration, and I wanted to quickly look at the definition of that, because that's sexual assault that you can commit against a male or a female. So I remember in one of the somebody mute themselves. There's a lot of background noise.
Yes, that my Lord just showed us back on.
Where that noise coming from? I wanted to refer to section 261, which talks about sexual assault. I think that scope of a man can come in under this section as well. I don't know that.
Sorry, my Lord. I think Justice Sholego's mic is still on. My Lord.
Sorry?
My Lord, Justice Sholego's mic is still on.
For a microphone. I don't see that it is her, but okay. Yes, so you are right to say that it is sexual assault, and that is section 261, I think. I was looking at it a minute ago in my presentation, which says that any person who penetrates sexually, has penetrated sexually the anus, vagina, mouth, or any other opening in the body of another person with a part of his body or anything else without the consent of the person is guilty of a felony and liable to imprisonment for life. So yes, I think that comes under sexual assault, and that's what we have so far. Unless we're able to adopt, that definition in VAPP, for instance. But it's a crime, and it can also be dealt with. It's a question of proof, like we've talked about, and how the prosecution seeks to prove it. So I hope that has answered the question, because I think that's what I got, whether it's punishable or whether it is a crime. I think that's the question, unless I didn't get the question.
Thank you very much, my lord. At this stage, I think we'll close down the discussion on that aspect. My lord, we'd still like you to stick around. I use that word because we're still going to come back to you at the end of the proceedings. At this stage, I only see Shola Shoele online, so Ms. Shola, you can start your presentation. I haven't seen Mrs. Faiwadini yet. So Shola, if you're there, please, you can come up. I think everybody knows Shola Shoele. Thank you. Shola, are you there, or you're still busy editing? Okay, I think I saw. Okay, yeah. Mrs. Faiwadini, please go ahead and start. Just unmute your mic, and everyone else, please mute your mics. Mrs. Vigo, please, you can unmute your mic.
Okay, good morning. Good morning. Please, can you hear me?
Yes, we can hear you.
I don't know where you are, but the connection is not very good.
Hello?
Oh, yeah, your connection is not very good.
Okay, can you hear me now?
Yes, I can hear you now. We can hear you now.
Okay, thank you so much. Good morning, my lords. Permit me to please stand or sit on the existing protocol. It's a privilege for me to be here. I congratulate MBA Ikorodu branch for having this virtual meeting on sexual and gender-based violence. I was asked to briefly share legal provision and our expected protocol response in handling domestic and sexual violence in Lagos State. So I will just share my slide as I begin my presentation. Kindly let me know what
Hello, Lola, you have like 20, 25 minutes. Can you hear me? Okay, you have like 20, 25 minutes, Lola.
Sorry?
I said you have like 25 minutes.
25 minutes. I'm grateful, sir. So very quickly, we're talking about the domestic violence law, the law that, the particular law that was enacted to protect the rights of survivors of domestic violence law. And the law is the Protection Against Domestic Violence Law, enacted in 2007 and was amended in 2015. The law is made not only to protect our women, who are most times the target of domestic violence, but also to safeguard the interests of men, children, servants, maids, and everyone who may be a victim of domestic violence. As I said, it was enacted in 2007. It was sponsored by an Untitled Chapter. Yes, and it's actually we're the first state to enact a law that protects the victims of domestic violence. The law has just 19 sections in total, but it's such a potent piece of legislation, and I do not think we have truly activated it enough as we should. The law is quasi-civil and criminal in nature. The major aim of the law is to guarantee the protection of victims, not to punish. It envisages a situation where somebody is in distress and the person needs to be protected, right? And so the aim of that law is to protect persons that are experiencing domestic violence. Section 1 outrightly prohibits domestic violence by providing that from the commencement of this law, no person shall commit any act of domestic violence against another person. Now, who can apply for assistance under this law? I do not want to take for granted that the participants here are aware, but just to re-emphasize the fact that anybody who is in a domestic relationship can apply. Anybody in a domestic relationship that is experiencing violence can apply for relief under this law. However, furthermore, the section of the Protection Against Domestic Violence law, particularly Section 18, enumerates the different types of relationships that amount to domestic relationships, to include persons who are married, which include not just limited to married under the Act, but also native law and custom, people who are cohabiting, parents or guardians of a child, family members, housemaids, domestic servants, staff, and housekeepers. Before I was privileged to work in the DSVLT, or before the establishment of the DSVLT, I had that impression that people who cohabit is something that is peculiar to foreigners or people in the Western world. But since I've been working in the DSVLT, I can say that we have at least 50% of survivors that present themselves at the office are cohabiting. They have no formal union or formal relationship. They're just cohabiting. They've had the first child, they've had the second, they've had the third. But under this law, even if you're cohabiting, you can still access some relief pursuant to the law. Okay, so people who are married under the law, including marriage and custom, people who have lived together and when are in a relationship in the nature of a marriage, and people, although they were not or are not married to each other or are not able to be married to each other, parents of a child or persons who have had parental responsibility for a child, family members related by consanguinity, affinity, or adoption. They were in an engagement, their engagement was called off, they were dating. As far as they have a cohabiting relationship, a person can access the services or the relief provided for this law. Now, what can they access? The aim of this law is to protect, as I said, and this is done by through securing a protection order or a restraining order. And this is provided for by Section 2 of the Protection Against Domestic Violence law. And the law allows a complainant to apply for a protection order by him or herself. And we understand that survivors can walk in to any magistrate or high court and make that complaint. And when the complainant has legal representatives, the lawyer obviously can do this on his or her behalf. Now, the court has a duty, upon receipt of that application, to issue a protection order An interim protection order can be issued against the respondent even without notice of the proceeding in a prescribed manner. The respondent, especially when there is evidence to buttress the fact that the respondent has committed or is committing an act of domestic violence, and undue hardship may be suffered by the complainant as a result of the domestic violence if a protection order is not issued immediately. So I believe that the drafters of the law, what they had in mind was that a person is experiencing violence, the person should be able to rush into any magistrate court or high court, speak to the registrar. This is what I'm experiencing. Based on the evidence that is before the registrar informs the court, and an interim protection order is issued, and that interim order is valid for 8 days. What are the different orders apart from the restraining order that the court can make? This is provided for in Section 7 of the law. It can empower, the orders can include an order to stop the respondent from further committing any act of domestic violence, an order prohibiting the respondent from enlisting the help of another person. We've had some instances where perpetrators will not be the ones to physically assault the survivor or the client. They would ask their driver or the housekeeper or the gardener to be the ones to hit or physically abuse their spouse. The order can be extended to such people. It can also be extended to restrain the respondent from entering the residence shared with the complainant. When we say this, people say, Lola, this is Lagos, this is Nigeria. Why are you talking as if we're in London? I'm not the one saying this is what is provided for in the law. And as far as the law is concerned, the law is trying to protect a person who is experiencing domestic violence from and to prevent a respondent from perpetrating any further form of violence. The order can also be extended to the complainant's place of work. We have some people that take the abuse outside the home. They constitute themselves as a nuisance. They go to the place of work of the survivor or the client, knowing fully well that if the authorities are aware that this is happening, most times the human resources will say, Madam, please go and sort out your domestic issue. And so the order can actually be extended to the complainant's place of work. The order can also compel police officers to accompany the complainant to a specific place or home for the collection of their personal property. Let's not forget that these things, most times when it happens, is in the heat of the moment. The survivor doesn't have an opportunity to grab her things or grab her personal documents and all of that. So the order, the law envisages that. And so the order can also instruct a police officer to accompany the complainant to assist him or her in retrieving their belongings. Please note that the court can also grant maintenance orders, which include but not limited to payment of house rent or mortgage, feeding allowance, school fees for the children, monthly expenses, emergency monetary relief. And emergency monetary relief include loss of earnings suffered as a result of the violence, medical expenses. We actually had a lady 2 years ago, as a result of the domestic violence, she lost use of her left leg, so she had to undergo surgery. I think she had spent close to 2.5 million naira before she reported to government. Of course, if that case was to go before the court and the man has the means, the alleged perpetrator has the means, the order can be extended to include that he should pay for medical expenses that she has incurred, relocation and accommodation expenses, and of course, necessities. So the essence really is to ensure that this person is protected. You would agree with me, for people that are privileged to meet survivors of domestic violence, most times they do not want to prosecute the abuser. What they want is they want the beating to stop. And some of them would say, you know what, I'm done with this relationship. I just want this person to leave me alone. I want this person to provide for the children. I want this person to provide accommodation. These are basic things that a survivor really needs. And truly, those reliefs can be gotten upon making an application to the court for a restraining order. Now, the law encourages busybodies. The law wants each and every one of us to be busybodies. The law wants us to be able to act on behalf of victims or survivors. And it empowers certain individuals or organizations to bring applications on behalf of survivors of domestic violence. Some busybodies include counselors, health service providers, police officers, social workers, NGOs, teachers, lawyers, family members, parents, or guardians. And I think it is important that this is in the law, because we know by virtue of the psychology of domestic violence, some of the survivors do not even want to report, not because they are enjoying the abuse, but because they have been so battered emotionally. They are unable to take concrete decisions. They are so emotionally, some of them are so emotionally battered, they can't even take proper decisions as far to guide the course of their life, and where they are children, the course of the lives of their children. And so it is only right that the law empowers busybodies to act on behalf of survivors. Furthermore, the law empowers busybodies to act without the consent of the victim in certain instances. If the survivor is a minor, if the person has a mental health challenge, if the person is unconscious, i.e. the person has fainted in the process of the violence, and a party who does not want to give consent because of fear or because he or she thinks the court may refuse his or her application, and what might happen to him or her if the application is not granted. In these instances, a person, MBA, myself, yourself, we can make applications on behalf of survivors without their consent. Who has jurisdiction? The magistrate.
Did we lose Lola there? I think we lost Lola there. Before she comes back in, I would like us to prepare questions for Lola in this conversation and have some thoughts. In the meantime, if the FIDA chairperson, Ms. Zineji, if you're there and you want to say one or two things, you can unmute your mic. Mrs. Odulami as well, if you want to say one or two things, you can unmute your mic and give Lola some time to get back online. Perhaps any other person, any other person from FIDA who understand the vice chairperson is also there, so that we do not waste our screen time. Maybe I should just open the floor for anyone who wants to say or add to what Lola was talking about. Anyone? It is a training session for lawyers, so knowledge.
Before people wait now, before people start seeing it, before people start seeing that we promise them and I give us something. If the man say they want to, I'll wait.
Ms. Nena Mani.
Yeah, good morning. Hello?
Okay, I think
Good morning.
Lola is back online.
Good morning. Good morning. Good morning, the chairman. Hello?
Okay, Mr. Namani, we can come back to you later. I think Titi Lola is back online.
Okay. My question is, can I go on with my question?
Please proceed. Please proceed.
Please, I appreciate the knowledge I've gained. I'm particularly grateful to the MBA and our chairman, distinguished guest, Honorable Justice Williams. But the question I want to ask, in the event that the order being sought by a victim or a complainant in a domestic violence matter, where it is granted against the respondent, maybe to restrain him from further act of violence, is it the same procedure of enforcement of judgment that will be followed? Maybe before then, the victim would have been killed. Or is there any particular measure in the law that will make the enforcement faster to protect the victim? That is my question.
Okay, so we'll note that down, Justice Williams. We'll note that down, and then we'll come back to Mrs. Vaigwadini. Welcome back.
Thank you very much. So sorry for the breaking in transmission. So sorry, Steve. Let me just resume. I'm wrapping up. Okay. So yes. So we're looking at yes, the legal provisions on sexual violence in the state. So we have Chapter 25 of the Criminal Law of Lagos State that highlights the different. I don't know if this has been discussed. I'm sorry, but just to state that we have 263 sexual touches without another's consent. Section 264, sexual harassment. Section 265, causing a person to engage in sexual activity. Okay, so ingredients of the offense. For defilement, Section 137, any person who has unlawful sexual intercourse with a child is guilty of a felony and is liable to imprisonment for life. Here, this section, consent does not arise because the child cannot give consent. Once you have sexual intercourse with a child, you are guilty. If it's proven, you're guilty of the offense of defilement and liable to imprisonment for life. Now, we have the offense of rape. This is traditional rape. Any man who has unlawful sexual intercourse with a woman or girl without her consent is guilty of the offense of rape and liable to imprisonment for life. So rape can only be committed by a man, and there must be unlawful sexual intercourse, and it must be between a woman, it must be against a woman or girl. And that girl does not give, the woman does not give her consent, and it's life imprisonment. Now, top 2 goes on to highlight elements that vitiate consent, which include force, impersonation, threat, or intimidation of any kind, fear of harm, or false or fraudulent representation as to the nature of the act. And so, of course, it's not, most people think that there must be force in rape. There must be a struggle. And that if the person did not struggle, if the person did not shout, if the person did not scratch, then it is not rape. The woman consented. No, people react differently. I had a client, she said it was just, the man just said he has a gun in the back of, in his bag. And she just froze and she allowed him, quote and unquote. She didn't struggle, she didn't shout, she didn't scream for help, she didn't scratch, she didn't bite. She allowed it, but she was afraid that this man was going to kill her because he said he had a gun in his possession. Now, top 3, sexual intercourse between a man and a woman who are married is not unlawful, meaning under this section, a husband cannot rape his wife, right? Then sexual intercourse is complete on the slightest penetration of the vagina. So we've moved from there must be penetration into the labia majora and the labia minora. No, it is complete upon the slightest penetration of the vagina. And please note, rape is also life imprisonment. Section 261, sexual assault by penetration, we call this modern rape. And this is any person who penetrates sexually the anus, vagina, mouth, or any other opening in the body of another person with a part of his body or anything else without the consent of the person is guilty of a felony and liable to imprisonment for life. We've had cases of women inserting spoons into the vagina of 2 years old. We've had people inserting bottles, sorry for being graphic, inserting bottles into the private parts of the woman. We can't charge for rape in those instances, but we can charge for sexual assault by penetration. Also, people that digitally penetrate children with their fingers, that's not rape because there's no sexual intercourse. There's no male genitalia into the, it is, the person is using any part of their body. And please note that this section is not a respecter of relationships. And so a wife can actually say that she has been sexually assaulted by her husband because this section is not a respecter of relationships. Attempt, section 262. Any person who attempts to commit the offense of rape or sexual assault by penetration is guilty of a felony and liable to imprisonment for 14 years. We've had situations where the person is attempting to do it. Maybe somebody comes in, catches them in the act, and they call for help and all of that. And then they go to some police stations, or they go to some health facilities, or they even engage NGOs. And the response they get is, oh, well, he did not do it. He tried to do it. So let us drop the case. No, it's an offense punishable by up to 14 years imprisonment. Sexual assault, any person who sexually touches another person without their consent is guilty of a felony. I think this cannot be overemphasized. And I think it's really women that bear the brunt of this. You're going to a market, especially there's some very interesting markets like Yaba and Lagos Island. Everybody is grabbing you, tossing you, holding you, fine girl. And then if you now mistakenly respond, they will start to insult you on top of the assault they have, inflicted on your person. So it is an offense, and it's like the punishment is 3 years imprisonment. Okay, sexual harassment. Yes, we have the bill that I believe it's gone through the Senate. We're waiting confirmation from the House of Representatives before it will be transmitted to the President for assent. But I think it's a breakthrough landmark bill on sexual harassment because of the impact sexual harassment can have on a person. Students have carried over courses. People have been frustrated out of jobs because they have rebuffed and refuted the sexual advances made by their superiors, their teachers, or their employers. We had a client that attempted suicide because she had been so sexually harassed by her employer. And unfortunately, she did not have another source of livelihood, so she had to still remain in that hostile environment. It is an offense punishable by up to 3 years imprisonment. Okay, so just to quickly state what consent is, because when we're dealing with rape and sexual assault by penetration, when we're dealing with adults, issue of consent is critical. Consent is when someone agrees, gives permission, or says yes to sexual activity with another person. Consent is always freely given, and all people in a sexual situation must feel that they are able to say yes or no or stop the sexual activity at any time. Okay, so we have an acronym called FRIES. F for freely given. It's a choice. You make that choice without having pressure, being manipulated, or under the influence of drugs. It's reversible. Anyone can change their mind about what they feel like doing anytime. It's informed. You can only consent to something if you have the full story. It is enthusiastic. When it comes to sex, people should only do what they want to do, not what they are being forced to do. And it's specific. I can consent to being kissed. I don't necessarily consent to having sexual intercourse. But I think when we speak like this, we also take advantage of the fact that we need to also engage women as well. Because some people say, oh, she said no. but she meant yes. And there's a song that comes to mind that wherever you go, whoever you see, do not say yes when you mean to say no. I think as women as well, we should also be assertive. Our no should be no, and our yes should be yes. I have a video. I don't know if I have time to play the video. Mr. Kinade, it's a 2-minute video, security tips after sexual assault. Can I?
I think it's up to you. You're the speaker.
Okay, so let me just quickly play it. It's just basically information that everybody should really be aware of. Once a sexual assault occurs, what should we do? Because we need to start winning these cases using science, using forensics. We need to move from he said, I said, I did not do it, I did it, to actually establishing evidence. So we have this short video to play. Trying to look for it. Okay. Please let me know once you see it.
I think, Lola, there's no sound, so maybe you could just read out what you will say.
Okay, sir. Sorry about that. Yes, so following police stations in Lagos State have specifically trained police officers on SGBV crimes, and this include Adeni Diadele Isoko, Cape Police Station, Ikorodu, Festac, Badagry, Aja, Alakoko, Ikeja, and of course, Gender Desk, Lagos Police Command. For medical attention, please visit Mirabel Center, Warif, or any of the comprehensive family health care centers in Lagos State. They've been equipped with sexual assault evidence collection kits, also known as rape kits, for survivors of sexual assault. And please note that confidentiality is guaranteed throughout the process. And to any survivor, remember that you are not alone. Okay, thank you. So infographics, we found out that 88% of our survivors that present do not actually have real evidence. No pictures, no medical reports, no recording, nothing. And so that's why sometimes we have to use mediation as a form of alternative dispute resolution. We also found out that out of the clients that report, 20% were initially interested in prosecution, but then along the line, 18% withdrew their cases from court. because of pressure from the family, the society, our religious clerics. You cannot prosecute your husband, who will walk your daughter down the aisle, and all of that emotional blackmail. 88% of perpetrators deny ever physically assaulting the survivor. For those of us that engage perpetrators or suspected abusers, you would agree with me that there is always denial. I never did it. Oh, I didn't do it. Actually, it was 10 years ago. Actually, I just slapped her. Madam, she's the one that hit me. That's why I slapped her back. Denial. But then some would actually be honest and vulnerable enough to admit that indeed they did physically assault the person and they need help. Those are beautiful cases. I mean, the work has almost been sorted out. It's almost been done. We've almost properly addressed the issue. 70% of the perpetrators said they were survivors of verbal and emotional abuse when they were growing up. They witnessed intimate partner violence. And so they took that notion that if we want to settle issues in my own home, this is how I'll go about it. I'll go about it by flogging, by beating, by coercing, by compelling the person to subject their views to mine. 90% of the survivors were not financially independent as a result of the domestic violence. And because of this, they thought they had to remain in the abusive environment. 98% of perpetrators claimed that their spouse was having an affair. A majority of them, no evidence. There's a hunch. Somebody said they saw their wife at a hotel. No evidence, nothing. And yet, that is the reason why they have 8%. 78% of the survivors said they had previously approached religious institutions or family members for help before approaching government. So we cannot overemphasize the important role religious institutions play, especially as first responders to these issues. 85% of survivors blame third-party interference, mothers-in-law, sisters-in-law, of interfering in their homes and the reason for the friction in their homes. 98% of the survivors said they are remaining in the relationship because of the children. And I think we need to change this narrative because science has shown, studies have shown that children who witness intimate partner violence grow up for the boys to perpetrate violence and for the girls to be attracted to people that would physically assault them. So we are doing more harm than good by raising children in toxic and violent relationships. We are not preaching divorce, but it is people we need to raise whole children because it is easier. It is so difficult to correct a broken adult than to address a broken child. Yes. So
okay.
Finally,
you are going for the pattern. You know the
okay.
They don't send that to me.
Okay.
You are powerful people now. Pattern is going. Nobody can stop that.
The election. But if this Adele Gula or no spoil, you know, say he has gone to court now. And I today.
don't know what is wrong with that man.
But he's making serious man. Do you know that?
Mr. Dinamani, please, can you please mute your microphone, sir?
Okay.
Thank you so much, sir. Yes, so protocol response to handling sexual assault. The case can come in through via email, phone, office, social media. We want to believe that we are quite accessible. Our first response is, has the person received medical attention? If no, refer to the closest family healthcare center or the nearest SAC, i.e. Mirabel or Warwick, and ensure that the case is reported at the closest family support unit. Engage the FSU officer to ensure the arrest is made, is done, and case is charged to court. DPP request for the duplicate case file, and the survivor is accompanied to court. I think MBA Ikorodu has been doing an amazing job in this regard, liaising with the DSLT, ensuring that medical attention is given to the survivor, liaising with the police where necessary, and all of that. Domestic violence is not really clear-cut because survivors, we need to be survivor-centered when you're in this space. Half of survivors. So to get it, with the case, subject to report the case to police station, depending on the severity of the violence we're dealing with, or where the survivor insists that they do not want police intervention, they want the person invited. The person is invited. When necessary, case of legal representation, survivor is referred to OPD, MBA, Lagos Public Interest Law Partnership for legal representation. And then some of the cases we actually handle by assisting in obtaining restraining orders or legal representation for divorce or custody of children. Survivor or perpetrator is referred for psychosocial therapy if it's coming for mediation. Survivor is put in shelter depending on the risk involved. If we feel that there's threat to life, we can leverage on our partnerships with an NGO to provide shelter for the survivor. And where possible, survivor benefits from the domestic and sexual of cases that go through mediation, perhaps have no business at mediation. We need restraining on behalf of abusers. I think that MBA can also continue to provide legal representation to indigent survivors for custody or divorce proceedings. On a final note, I thank you very much for this opportunity. It's a potential murder case. It can be the last push, the last shove, the last kick. Let's not wait till it's too late. Thank you for listening.
Thank you very much, Lola, for that presentation. I'm sure it's a lot of questions raising in the minds of lawyers. So what we'll do is give us a few minutes. If you have questions, please note it down while I ask if Shola Shurili is there. Shola, are you there?
Sorry, sir. What did you say?
Shola, are you ready? Please get your questions ready for Mrs. Vigo Adeni while we see whether Shola is ready. Okay, maybe we should just take questions from the floor, and then anytime Shola comes in, we will break the question session and then allow Shola to speak. So anybody from the floor here who wants to ask a question?
My name is Olaomi Adiola. Flowing from this conversation, I would like to know, because seated in this room today, we have members of the Committee on Domestic Violence, Child Rights, and Persons Living with Disability. I would like to know what are the practical first steps to take when domestic violence victims approach us. Should we refer them, should we listen to them and refer them to the police stations, especially when they have, bruises all over their bodies, or just let us know the practical steps to take, please. Thank you.
Any more questions? Any more questions? Please, I will take questions again after.
Good morning. We've had a very nice session here. My love, the Lord, the fruit of his body. And my question is, my name is Soma. My question goes thus. One, in the Ikorodu MBA, we have an act of committee on domestic violence where we entertain the victims to people, families, on every Tuesday of every blessed week. And we do try to engage in the matters. In the first instance, usually when we have a complaint, we listen to the complainant, usually the survivor. Thereafter, we invite the abuser to listen to them. After listening, we try to come in between the two of them, try to mediate, and at some point, we usually strike a balance between the two. But we've had instances where they will not live up to our expectation or to agree terms. How do we enforce this between parties? Though most of the cases, they always agree with us. But instances where they fail to live up to their agreed terms, what do we do? Because we are an act of committee, not state established committee. We are just there to help the court. So what we do is not that system. Thank you.
Please, any more questions from those that are online? Please ask your questions. You can also text your questions. This is Odulowe.
Okay, good morning. All protocols duly observed. I'm Odulowe Alowonle. I would like to know why domestic violence keeps increasing despite all odds.
Please, anyone who has something to say or ask a question, please unmute your mic and go ahead. Okay, we'll just go right ahead. My Lord Justice Olushola Williams and my Lord Justice Sholebo, any one of you could just jump right in and speak, and as well as Lola, you could just jump right ahead and also try and respond. Thank you. There are also some questions on the chat box. Any one of my lords and Lola can also respond to. Thank you.
I think the questions are for Mrs. Viva Adeniyi, really.
Let's do that. Okay.
Lola, over to you.
Okay, so I got the last question. Why is domestic violence increasing despite the odds? I do not think domestic violence is increasing. And I'd like to speak with data. If we look at what we're seeing in the past 5 years, what we're seeing is increase in formal and informal reporting. I think maybe from 2022, we should now be able to do an assessment of data, assessment of the data generated from different local government. We should support services available. People know telephone numbers they can call to reach out for help. And the last point is political will. We have the policy in Lagos to address this many. We have the governors, the former governors, current governor. As soon as he came into office, he led a walk in company of the heads of the judiciary and the legislature. So we're seeing political will being demonstrated. You know, it's tangible. And I think that's why we're seeing increase in reporting of cases. These vices have always been there. Incest, domestic violence, sexual assault, they've always been there. But we have different avenues now where people can leverage, especially social media. These are issues that would have been swept under the carpet, you know, but now people are leveraging on their phones to report cases. Yes, so I think we're seeing increase in reporting of cases. The first question, I didn't quite get it.
The first question was steps to be taken once a domestic violence case has been reported to our committee. Lawyers need to know what steps need to be taken as first responders so that we don't mess up the case or we don't actually make a mess of the whole thing. Thank you.
Okay, thank you, sir. I think domestic violence, you know, when I spoke to the slide on protocol response, it's not clear cut because you're dealing with somebody who maybe does not even know what he or she wants. So I appreciate the fact that we have public interest. Domestic violence is also a criminal allegation, it's assault. So what we would be advising is we need to engage the survivor and have a survivor-centered approach. We need to take time to engage the survivor. What do you want? If the person comes to you fresh, of course, immediately take pictures. If the person has injuries, the person sustained injuries as a result of violence, immediately refer the person to the closest health facility. Let them be treated. And that singular action, we're trying to build a case, we're collecting evidence, we hope to preserve evidence. When we do those initial things, take pictures if the person is fresh, a crime scene in motion, refer to the health facility for medical attention, you can have a conversation with the person. But if there is threat to life, obviously, and the person does not have alternative source of shelter, then even reporting to the police does not really address the issue at that point in time. What we need to do is find out, is there a trusted family member the person can briefly reside with, or can you engage the suspect or the alleged abuser with a view to asking him or her to leave the property or leave the home for her, for the survivor, and if there are children, for the children. I think that's so we're engaging the perpetrator not to really delve into the domestic violence case, but to immediately solve the situation and ensure that this person is not rendered homeless. And then if we're fortunate and we have a survivor that is properly counseled, there is a difference between counseling and advice. We are not, as responders, we are not to advise. It is unprofessional, it's unethical. We are not there to advise. We are there to counsel. And I want to believe we appreciate the difference. Counseling is you tell me the options available to me. If I take option A, I approach the court for a restriction order. This and this is the overall impact. These are this is the likelihood of what is going to happen. If I take option B, I do mediation, this and this and this. If I do option C, I escalate to the police. So you help the survivor to reach a decision for themselves, so that it will not be said that NBA Ikorodu branch told me to leave my home, or this person, Lola, told me to do this and do that. No. When you counsel properly, the person will run with whatever decision they take. And anybody that asks them why they do that, they took it by themselves. You know, they own it and they run with the process. So I don't know if that has answered the question, but assess each case on a case-by-case basis. If you feel that there is threat to life, please, that person has no business returning back to the scene of the crime or that environment. If the person comes fresh, because we need evidence to prosecute these cases, or even to negotiate or mediate, we need evidence. Immediately take pictures, refer for medical attention. And then the next thing is shelter, accommodation. Does this person have a trusted family to stay with, or can I engage this alleged abuser to leave the premises, leave the house, for them to go back in? And then we can now say, okay, can we dialogue? Marriage is not by force. If you don't want to stay together, let's do this, let's do things properly. How would you pay for the maintenance of the children and all of that? I say this because when we just started the SDRC, I met a pregnant lady. She came to the secretariat around 7:50 a.m. Pregnant, heavily pregnant. I think she was 6 months gone. Bruises. She said the man had beaten her all through the night. Immediately we rushed to the police station. We got there, we got the man arrested. And we were pushing for the case to be charged to court. Can you believe that this woman came the following day? This pregnant woman, she came rolling on the floor in the office. That I didn't tell you people to arrest my husband. I did not tell you people to prosecute my husband. If you people prosecute my husband, who will take care of this unborn baby? And then it hit me that I was acting as per, oh yes, I need to do this. Public interest is important, but we have to be survival-centered. So whatever we do, we are not further traumatizing the survivors that are already traumatized in the first instance. So to handle domestic violence, you need to pay attention. You need to devote time to that person that comes before you. And with the information the person gives you, you will be able to properly counsel as to the different options that are available to him or her.
Okay, I have another question. We've had a situation whereby the matter was referred to us. It was a case of okay, the matter was referred to us, which involved a child that was raped. That was pedophile. And you know, some of our colleagues have to take that child to the general hospital for medical examination. Bringing the child back, the issue on the ground was, where will the child return to? In circumstances like that, what do we do? Where the victim cannot return back to the residence because the crime was perpetrated there, what do we do?
Lola, did you get that? You've muted your mic. Unmute.
Okay, I didn't hear it clearly, but I think there's a child that has been defiled. The child was taken for medical attention, but the child cannot be returned back home. Is that it?
Yeah, that's correct. What do you do?
Why can't the child? Is the parent an offending parent? Is it the parents that abuse the child?
Family relations, living in the same residence, I believe.
So why can't we get the person arrested? Well, it can go both two ways actually. We ensure that the person is arrested, removed from that environment with immediate effect if possible. And then, you know, because of the policy, the new protocol, the policy in Lagos, these suspects are brought by way of remand. So they are remanded pending the issuance of the DPP's legal advice. Or if we feel that that environment, especially when it's an offending parent, so it's a case of incest, then we engage the services of child protection unit of the Ministry of Youth and Social Development to get secure an emergency order, emergency protective order to place the child in a shelter. But we don't really want to institutionalize our children. We don't want our children to get lost in the system. And I mean, it's not the child's fault that he or she was abused. So instead of removing the child from an environment, why can't we remove the abuser immediately from that environment? So I think it depends. It depends on the level of animosity that the child may face if she returns back to the community.
Okay, thank you, Lola, for that. I don't know if my Lord Justice Sholem or my Lord Justice Williams would like to add to the issue of advice versus counseling. My Lords?
Advice?
Lola did mention that there's a difference between advice and counseling the victim. What would my Lord's views on that perspective?
Well, I think both have to be done. I guess advice to be talking about legal advice. What steps?
Yeah, but I'm the one who's getting over here. So on Monday when he comes, I'm definitely giving him A, B, or C. So he should go get it and start practicing before then. Hello.
Please, can you mute yourself? Okay, so I guess advice would be what's the next step to do, especially maybe intervention, like legal intervention, or this issue of talking to the police and all that. What legal steps can be taken to contain the situation. But counseling goes a bit deeper than that. It goes to the root of the problem and actually trying to solve it. And counseling is always important because one of the things that domestic violence does is that it actually affects the person emotionally. And there are a lot of studies about how the abused person is dependent on the abuser and cannot see themselves outside the abuser. So it affects their self-esteem, their sense of security, and their whole outlook is skewed. So it's important to have that counseling. That's just taking care of that whole person. So to have a holistic approach, there has to be both counseling and advice. Although there are two different things. I don't know if I've been able to make the difference, but both of them must be present. Because if you advise someone and that person hasn't counseled, they might reject your advice. They might not even know the value of your advice, are not in a position to actually take the advice. The good example she gave is the one who, this woman is pregnant and then she comes rolling the next day. I did ask you to arrest my husband, because she actually hasn't seen beyond the man as her provider. She hasn't seen herself as somebody who can stand up in such a situation. So those are the things that counseling does, to try to mitigate or stop the damage that is done to the psyche of the abused person, even the abuser, because we find people that the reason why they do, because they see it as a pattern. It's been happening in different areas of their life, their background and all that. But advice is, what are the necessary steps we need to do now to arrest, or what's the legal, as in arrest, and stop the abuse, or what are the legal steps, to prosecute and all that. So that's the difference that I see. And I think that to have a holistic approach, both have to be done, both the advice and the counseling. That's my own answer to that.
Sorry, my Lord, when I said advice, I don't mean legal advice. I mean, as a Christian, the Lord hates divorce. Or in where we are from, we don't do this. Why don't you? We have some people that would say, okay, after he has beaten you, what you do now? Go and buy a bottle of wine, kneel down, beg him, cook his favorite food. I'm not speaking about legal advice. I'm speaking about advice. You're coming from your personal intuition. This is what has worked for you. You're sharing your own personal take on the matter. You as a professional, you shouldn't do that. You should speak from a professional perspective. So if as lawyers, yes, of course, we should provide legal advice. Are you married under the Act? These are the rights that are to you as that's just what I was speaking about, my Lord.
Okay, so what you're advising us as lawyers and possible first intervention people is that we should not give moral advice according to our own moral standards. But what we need to do is we should look at the law, and from a professional standpoint, from what you've even trained us and what you've exposed us to, we should try as much as possible to stick to what the law requires in terms of intervention, not what I think as a Christian, what I think as a Muslim, or what I think as somebody coming from a family that has not seen divorce, or from a family that is polygamous in nature. So we should just stick to the law. Is that what you're saying, Lola?
Yes, that's what I'm referring to, please.
If this is what you're referring to, my Lord Justice Williams, is it possible for a victim or an accused perpetrator of domestic violence to sue the lawyers, just in case they gave an advice according to their moral position? Would that be an actionable thing?
For a long time, I have been advocating, and that's why I said that I am, there are so many issues. I want to be very, very much back in the bar. I don't see that being on the bench stops me from being in the bar, because I was always in the bar before the bench. That's, another story for another day. One of the problems we have with the bar is a total lack of regulation. I mean, I'm sorry, with all apologies to the NBA, but there is just, if there's any regulation, maybe 3%. I'm serious. And so we don't have professional responsibility. There's nothing really like, professional negligence cases. Because that is what would have happened. It would have been a case not actionable in any other way, except the fact that you didn't do your work professionally. Because what you should have done was to have advised me professionally, not according to your morals. If I wanted moral advice, I would have gone to my church. If I wanted in that regard, I would have gone to a marriage counselor or a psychological counselor. So when I came to you as a lawyer, as my first responder, I was expecting advice. And it would be very unprofessional for you to then start advising me according to your morals. I've had this experience before. Even me, my husband was beating me for 25 years. But I stayed. My children are now married. I'm so happy. See how I walked down the aisle on the day of the wedding of my children. If you leave now, where would the father of your children be when they are guests? It's ridiculous. It's part of your job. So yes, I quite understand what Mrs. Vibadeni is saying, and I agree that that is not part of your job, and that if we really had cases of as a professional negligence case, maybe we really need to start doing this, and then the bar would rise up to our responsibilities more than we've been doing. So, but in the present circumstances, I don't see how it's actionable either, other than maybe probably report to the Bar Association. What's going to happen after that? There have been so many reports made to the Bar Association, and a lot of people are complicit themselves. We are living in a society where, this is an evil that is accepted, and we're actually just trying to change, the reasoning. So I don't see that much will come out of trying to report a lawyer, but we can start from somewhere.
Okay, thank you very much, my lord. And we actually want you back at the bar. So any way in which you can come back, I'll be happy to support that move. I'm advocating anyway that retired judges, retired magistrates have a lot to offer, so they should be allowed to come back to the bar to practice extensively and actually mentor younger lawyers in the area of practice. And I think that's something that we can work on from the perspective of the NPA to change some of these regulations. Our time is gone. Unfortunately, Ms. Shoyele had some personal emergency. She was trying to get back online, but she couldn't. We will have her on another day. So at this time, my lord and Lola, any last remarks? We did a virtual presentation to my lord and Lola That's why we were insisting that they physically show up here today, but that wasn't possible. But any last remarks while we prepare your virtual refreshments and your virtual awards? So Lola will go first, and my Lord Justice Williams will round up.
Okay, thank you very much. Also underscore the fact that we're dealing with lives. A person has been abused, as I said earlier on. It's a potential murder case. We should not treat it with levity. We should, if the person has summoned courage to approach us as first responders, we should do everything within our professional ability to ensure we're able to get justice for that person. And therefore, sexual violence, it can happen to anybody. SCBV is not a respecter of class, creed, age, sex, religion. Anybody can be a victim of sexual violence. Each one of us should see ourselves as mandated reporters. If we see something, we should say something, and we should do something. Thank you very much.
Sorry, my Lord. My Lord.
Yeah. I just want to say that sexual violence, like Mr. just said, is not just that it can happen to anyone, it is actually rampant. You know, people have used the word that it is a pandemic. And I remember someone asking, why are there more cases of domestic violence? That's the difference. It is just that we're getting enlightened and there are more reports. People have endured all sorts of things. She talked about Yaba market, for instance. I mean, it's so ridiculous. A woman is going, somebody pats her on her behind. And you think, oh, I'm just showing that I like the person. Or somebody touches a woman sexually, she doesn't like it, and she slaps the person's hand and she gets a serious beating. How dare you touch? And you know, all these things. We're living in a society that we're trying to train people to understand what actually sexual abuse is, because we lack understanding. And so I am so grateful and glad, you know, for Ikorodu branch of the NBA. And I think this is what must be done, not just once, but continually, to continue to educate and advocate. Because we have so many rape apologists. I'm on a WhatsApp group of legal practitioners. And one of the practitioners said in that group that all this rape that we're talking about, this is a lawyer, all this rape that we're talking about, the fact is that they should just legalize prostitution. That's the problem. Men need to relieve themselves. And I said, you're a rape apologist. Rape is not about relieving yourself. It's about dominance. It's about abuse. It's about violence. So there is need for continual training. We need to understand, you know, the legal aspect is one thing, talking to lawyers and all that, but actually educating men of every group. And okay, yes, women rape too and all that, but if the whole society is educated, then we have more. So we have a lot to do in the way of educating and advocating against violence. So I really, you know, want to congratulate Ruba, and also, you know, kudos to you. I pray that you keep up the good job and affect other branches of the Bar Association, because this is something that really needs to be done. Thank you very much.
Thank you, my Lord. I noticed that the computer made my Lord the host because my Lord was saying good things about Ikorodu Bar. So switched immediately and made my Lord in charge. My Lord, once again, I thank you for doing this with us today virtually. And I would like to call on the chairman of the Nigerian Bar Association, Ikorodu branch, to present my Lord an award.
Thank you, my Lord. May I also say, like Honorable Justice Suleiman said, that my Lord, I was not surprised with the presentation, Having been a student of my Lord at the law school, I believe we were at the law school together with Honorable Justice Shumibo in 1996. So my Lord was our senior lecturer there. So, and having practiced before my Lord, I'm not surprised with the presentation and the erudition in your Lordship's lecture given to us this morning. Having said that, my Lord, I want to, on behalf of the Committee on Domestic Violence, Child Rights and Persons Living with Disability, NBA Ikorodu branch, to give this special recognition award to your Lordship, Honorable Justice Olushola Williams, retired but not tired, for your protection of the rights of honorable people. This award is given to your Lordship today, the 24th day of July, 2020. On behalf of the entire membership of the Ikorodu branch, I appreciate your Lordship, and I hereby present this award to your Lordship. Thank you very much, my Lord.
Thank you very much. I'm honored.
My Lord, thank you once again. The next presentation will be done by the Vice Chairperson of Nigeria Bar Association, Ikorodu branch. Actually, she is the one who thought about these programs, and it's because of how we have all this headache trying to set up this whole thing. And I really appreciate her personally. She will be giving this award to another fierce lady, you know, also on the other side working for government. So we must.
Thank all the presenters for today. All we thank all our facilitators for today. We've been enriched with your depth of knowledge about domestic violence and rape. What you've taught us today will go a long way to assist us in doing our best for our community. Now, on behalf of Committee on Domestic Violence and Child Rights and Persons Living with Disabilities, NBA Ikorodu, we are giving this special recognition award. This is proudly presented to Titi Lola Bible Adeyemi for your protection of the rights of vulnerable people. Today, this day, 24th of July, 2020, by the NBA Committee of Domestic Violence. We appreciate you so much.
Thank you very much. Thank you so much.
Before the vote of time, if we want to do something special out of our way, out of our program for the day, we have this special award that we are giving to our chairman emeritus for helping us so far, for being with us, for guiding us, for putting us through all the way from the beginning of this committee to up to where we are now. We thank you, Survival and Innovate. The award goes us. Committee on Domestic Violence, Child Rights and Persons Living with Disability of NBA Award of Recognition. Presented to Adebayo. Yes. I must sincerely tell you, we kept this away from him. We never, he never allowed him to do anything about this. But we want to recognize him. He's been there for us, and we appreciate him. Congratulations. Congratulations. Thank you for ever vibrant years. Ever vibrant. Yes. Small but mighty man. Yes. Thank you.
That's a serious coup d'etat that just happened now, but I appreciate everyone. And like I said, the passion that drives the members to do what they do every Tuesday actually encourages me to provide every kind of support that they need to be able to do their work. So at this time, I'm going to give the mic back to the chairman of the Bar Association to make some remarks. And then we'll ask the vice chairman to do the vote of thanks. Mr. Chairman, sir.
Thank you, Mr. Bayo. Congratulations on the awards. It didn't come as a surprise to me because Mr. Akilade was his administration gave birth to this committee, and we are continuing with the committee because of the importance of the work the committee is doing. And we plead our own support also to this committee. We are going to give you all necessary support to make sure that your performance will surpass that of Mr. Akilade's administration. This program, as packaged by the Domestic Violence Committee of NBA Ikorodu branch, is our own little way of contributing to the advocacy against rape in our various communities. And from experience, we find out that out of a whole lot of cases of rape that we have, it's only few that get to the court, that are charged to the court. But unfortunately, even those few, either due to societal influence, most of it, when it comes to the victim coming forward to come and give evidence, you will not see them. At times, it's also due to non-conviction of a perpetrator. It's also due to the fact that lawyers handling the case of a rape, they don't have the necessary training, they don't have the necessary experience. So you find out that in the course of prosecuting the case, at the end of the day, most of the perpetrators get out of the hook and they go back to the society and continue where they stopped before. So this training is very, very timely. And I thank the facilitators for making it possible for us to have this enriching training today. Thank you very much. Mine is just to make a remark. I call on the vice chairman that doubles as the chairman of Human Rights and Domestic Violence Committee to give the vote of thanks. Thank you very much. And I thank my colleagues also for calling. Thank you very much.
Thank you very much. I want to say something before the closing remark. One or two things. One, we do hear about rape cases of rape being reported. Prosecution of that offense has been a bane. It has been something that has got the rape cases on the increase. We only hear about reports. You report case matters. You report. Prosecution, where has it led us to? Is either the police are doing something about the evidence, or the courts are not doing the way they have to do it. So it has been a bane, it has been a problem. Maybe I suspect that may be the reason why cases of rape has been on the increase. Then recently I was talking to one VP of the police station. He was telling me that they are underfunded when it comes to reporting cases of domestic violence and rape. That from their station to Mirabel Center, who bear the brunt of cost of transportation? Is it the victim, molested person, or the abuser? That it has been a problem. So at the end of the day, evidences may be silenced and we may not even get to anywhere. that we need an independent donor, an NGO who has a passion for this job to come on board. Not even the government, because the government may have government funding. There might be issues that may arise from it, but an independent donor, an independent NGO who has the passion to get a result from what is happening, that may be of help to us. In addition, he said something again that I want to point out at this forum. There's newspaper reporting of cases of rape. That in most cases, particularly all these Yoruba newspapers, they will say it this way: Baba, something has defied so and so person, as if glorifying that abuser. Not that Baba something, Kiri and Wareo, that's the way. He's going to life jail because of something. So people always want to, in most cases, they will always listen to the beginning of that news, but not what followed. That we should change the way cases of rape are being reported. That if they say that Baba something as Kiri and Wareo, something of that nature, that will allow the tension of an prospective offender to come down, because it's a jail term that is being meted on the perpetrator. Thank you. On this note, I want to say thank you so much to my Lord Olusola Williams. We are so grateful to you for giving us your time, your data, and your energy to teach us something more than what we've known in the past. God bless you, man. We are still expecting you to be a front liner at the bar, and we'll kill behind you. We are waiting for that. My sister, Lola Adeni Bible, we are grateful to you for your depth of knowledge. God bless you. We appreciate you. Ikorodu appreciates you so much. Forward ever and backward never. Thank you very much. God bless you.
Okay, thank you very much. And lastly, we want to thank the Olatun Olabinjo Women and Girl Child Initiative. And the initiator is right there. We want to thank the OPD, the CMC, DV, Domestic and Sexual Violence Response Team. We also want to thank FIDA as well, FIDA Lagos, Aula, Spotlight Initiative, Lions Club. Thank you very much. They were with us throughout the outreaches on the first and the second day. And we also want to thank British Council Roller Program, who came through for us at the last minute as well. And generally, the Ministry of Justice, we thank you. And lastly, we want to thank the Lagos State Judiciary for all that they do. And we hope that we can have more partnerships together. Concerning the training materials, I think we can connect with our speakers and we can get it to everyone. This session has been recorded, so we will be spreading the news across, and people can also have opportunity to download them. So thank you very, very much for spending the time with us. It's been a very productive 3 hours, and I wish you a happy weekend. God bless you all. Bye-bye.